Folks, this is a brief chapter at the very end of the book, and we're just going to spend a few minutes talking about this. This is called The Law and the Entrepreneur, and basically a lot of this is repetitive of material that came from, say, the middle of the textbook, and then they repeated it, repackaged it a little bit. And the main thing is that, you know, if you're thinking of starting a business, I always recommend that you have 4 key professionals. Certainly you should have a lawyer, and I was joking around about this earlier today, is you don't want a divorce lawyer to help you set up your business. Get a lawyer that is in the business of setting up businesses, or that especially set up some small businesses, entrepreneurial ventures. Secondly, having a good banker, and don't overlook credit unions. We do business with a credit union rather than a regular commercial bank because we're little guys, and we find that the credit union seems to be taking pretty good care of us on a first name basis. The people that work there seems like a pretty friendly operation. Fees are less. So obviously your bigger operation, multinational operation, you can do business with one of the major banks or commercial banks that are in the business of lending money. And so there's a variety of ways that you can get there. The other people, it's good to have a commercial insurance agent. Many of us use companies, heavily advertised companies, State Farm and Nationwide, Allstate. But keep in mind that they are primarily focused on the consumer market, and you may have your auto insurance and your homeowners. However, as you set up your business, you may want to consider partnering with a commercial insurance agent, sell a wider variety of products, and products that are better suited for your business also, that may be able to provide some advice to you as the type of business insurance that normally you wouldn't be alerted to if you're going through one of these more residential, if you will, and domestic type insurers. So some things to think about there. Of course, the 4th professional we recommend is obviously a good external accounting firm. In fact, if you are banking, if you're borrowing money from a bank, you're probably going to need to have a certified public accountant audit your books and provide some statement that your books are legitimate, because that's the basis. Again, as individuals, we submit our tax returns to apply for a mortgage. Parallel to that is a financial report prepared by a CPA who's not an employee of the company, who goes in and says this is what the company looks like financially. So this is some of the basic steps that we recommend. The other one that's recommended in this chapter is a business form. A couple pieces that I want to mention just quickly here is that one of the things is that when an attorney represents a business, they represent the business as a unit and represent all of the owners together. So one of the things you want to be careful about is if, say, you wanted to take over a LLC, one of the several members of an LLC, you want to consult with your attorney about buying out the other members. You do not want to do that through the LLC. You want to do that individually, because if you involve the LLC directly, you're representing everybody in the LLC and not just the person that you think you're representing. So I've actually had that come up where we had to say to the person, no, you need to pay us out of your personal account because you want us to give you advice as to taking over your other owners in the LLC. So something to keep in mind. So again, with attorney-client privilege, it's who's the attorney you can find. So if an attorney does business for the LLC, all of the members have a right to know what that attorney knows, not just selectively one or the other. So you don't have attorney-client privilege. If you're part of an ownership group, all of the owners have the same right to that information. So again, think that through if you're involved in, especially LLCs or other. One of the areas we see people getting in trouble is if they're under restrictive covenants from their previous job. You need to make sure that you actually have a clear right to go to work. Best advice I can give you, please be careful about signing pre-employment agreements. Make sure that you understand the agreement. If you're not certain of the impact of it, take it home, have your attorney review it before you sign off on anything. It is much easier to not go to work for a company or negotiate the non-compete in advance than it is to try and fix it after the fact. To give you an idea of what we can accomplish, I represent a young executive who had worked for a very large company here in Houston, had gone away and worked someplace else for a few years, had been hired back in a much higher position. And so since we knew we'd already left once, we wanted to make sure that he was able to feed his family, as he said, and not be stuck without income if the company fired him. So we spent a lot of time negotiating the severance agreement, but we also negotiated the non-compete. We actually reached this agreement. We named 8 companies that he could not go to work for in the 2 years after he left the job, regardless of the reason. So we actually listed 8 individual companies, and they said, as long as you didn't go to work for those, everybody else is fair game. But it's a clever solution. Also, we had some people recently who were under a restrictive covenant. They couldn't solicit employees from their current company if they went to a new company. We had the people who were going to go leave first. So the people that are going to go with them have already gone. And then he went in and negotiated the deal with the people on his own restrictions with my counsel. And we got a real good deal worked out where the company agreed to cut him loose completely, subject to certain conditions, which included the fact that he agreed to stay longer and persuade the other people to stay longer. So the other people, instead of leaving December 1, are going to leave December 15. He's going to stay until January 1 because the supervisors working with him wanted to make sure that he made his bonus. So it's real interesting what people's motivations are and things like that. But that agreement contained an arbitration clause in another state. You'd have to go to that state to arbitrate. The law of that state would apply. That is the state that enforces non-compete agreements. So a big concern. But again, always want to be careful. It's so much better when they want you and they're really interested in getting you on board. That's when you have the most leverage. Now, obviously, if you're negotiating individual employment contracts, there's a lot of factors involved in that. So some keep on. In addition to covenants not to compete, I wanted to mention quickly that here in Texas, again, this is a spotty situation. You can certainly be sued here as to whether you lose the lawsuit. It's relatively hard to enforce non-competes in Texas, but we don't want people taking chances or spending many thousands of dollars on legal fees working these cases out. So that's the reason we want you to be careful on the front end. But what happens is that the judges here in Texas are politically elected. They don't like hearing that you can't go to work tomorrow. That doesn't make them look good in the public. So the judges tend to lean against enforcement, but you could be the test case. Also, if you spend $10,000 in legal fees, you're not going to feel very good either. So be careful about that. One of the other things to keep in mind is that many employers today, because there's so many of these non-competes out there, are going to take the position that if you have a problem, it's your fault. You have to cover legal fees. The companies are not going to come in and try and bail you out. They might in some cases, but generally they're not. And they'll tell you that up front. Also, a lot of companies today are using statements that you have to sign that say that you understand that if you have a provision that you're responsible for dealing with it, not the company you're going to, and also that they are not going to afford fees. But a bigger statement in a lot of these new agreements say that you're not bringing any materials or any proprietary information of your previous employer, because they want to be divorced from whatever somebody alleges about your deal. This strategy on that, of course, saves the company money and time, but also what it does is it removes a deep pocket incentive. Because the other company doesn't have a chance to go after you, go after the other company, they can only go after the individual. Then that individual doesn't have the resources of another company behind them. So lots of considerations there. We're not going to go over the next few slides, talk about business forms. As you know, LLCs are the most popular form of business today, especially for startups, but there are a variety of other ways to do business. Those are the next few slides, liability corporation.